made to reaching a verdict in this case. It's evidently clear to everybody involved that this jury tried their hardest. They gave up a month of their lives, and unfortunately, after 5 days of deliberation, we're not able to reach a unanimous verdict. It's obviously not the outcome that I think anybody wanted in this case. Both sides, I think it's fair to say, desire a resolution to this matter. They desire a verdict. And this outcome clearly leaves a lot of unanswered questions and a lot of unfulfilled hopes, I believe, on both sides. At this point, what we intend to do at the District Attorney's Office is to consult with Anne Marie's family, with her parents, Bill and Lucy, her brother Chuck, her uncles, her aunts, and take into account their wishes and their position at this time. This process has taken an enormous toll on them, but they appear to be in this for the long haul. And I haven't sensed anything in their resolve or their dedication to stop their fight to see justice achieved for Anne Marie. We'll be consulting within the District Attorney's Office amongst ourselves, reviewing the case. And at this point, the parties have agreed to return to court next Tuesday, February 11th at 3 o'clock for a status on the case, for both sides to report to the court what they see or request the next moves to be in this case. In the meantime, the defendant will be held without bail, as she has been since her October 2011 arrest. And at this point, as I said, I think we're all just taking a step back, consulting with our colleagues, consulting with the family, and determining what would be in the best interests of justice moving forward. So at this point, I'll open the floor to any questions that folks may have.
Steve, this mistrial was declared almost coincidentally about the same amount of time it took the first jury in this case, about 24 hours, give or take. Would you have done anything differently this time around? And if you try the case again, will you do anything differently? It seems like you're locked in the same position here that you were a year ago.
We felt very good about how this case went in. Absolutely did. And I think that there's a fundamental difficulty with some juries, perhaps. We can't ignore the fact that we are asking 12 men and women chosen randomly from the community to convict not only a defendant of murder, but a female defendant of murder based almost exclusively on circumstantial evidence. And that's a tough task. No ifs, ands, or buts about it. It's a tough task. And we realized that going into this. We realized that when we brought this case to the grand jury back in October 2011. The grand jury overwhelmingly voted to indict, albeit at a lower standard of proof. And we know from the first jury, at least some of the feedback that we got, that the majority of the jurors from the first trial were convinced beyond a reasonable doubt of Cara Rintala's guilt. We obviously don't know which way the 8-4 split broke down in this case. Perhaps if any of the jurors choose to come forward and share that, we may know. But we have confidence to believe and enthusiasm to believe that there is proof beyond a reasonable doubt here that Cara Rintala killed her wife. So in terms of doing things differently, anytime you go through a process, you look back, you may make some revisions. In hindsight, you may decide certain things worked well, certain things could be improved. And ultimately, if the decision is made to press the case to trial a third time, we'll absolutely engage in that process again. I think it'd be foolhardy not to. Fred?
Is there some sort of standard by which her being held without right to bail would change automatically, or is it until the status conference? Or?
Well, until at least next Tuesday, she'll be held without bail. She cannot be released. If the defense moves for bail, it would once again be discretionary on the judge's part. There's no automatic rule that a person gets bail after 2 hung juries or doesn't. It would be the same discretionary factors the judge used in the first instance: the seriousness of the offense, her ties to the community, her likelihood of flight. So that would be entirely discretionary if it comes to that.
Would you oppose that if they move to set bail for her?
I really am not going to take any position or predict what our position would be on any matter at this point, whether it be proceeding to a third trial or any arrangements for her bail. Yes.
Are you already planning on possibly retrying her again? Have you talked about that?
It's absolutely an option. It's on the table. Everything's on the table at this point. But again, until we've consulted with the family and until we've consulted with the district attorney and our colleagues, we're just not in a position at this point to firmly commit to anything.
Can the state do that?
It can. Under the case law, when there is a hung jury, when there's a necessity for a mistrial, which the judge found in this case, there is no double jeopardy bar to moving forward, so long as the evidence is deemed sufficient to go to the jury. And if there were an appeal based upon the sufficiency of the evidence, it would essentially be the same standard that the judge used in denying the motion for required finding of not guilty when our case closed.
Steve, do you know of any other cases, either in this county or anywhere else for that matter, where a case has been tried a third time or perhaps more after a similar situation like this, where there have been 2 previous mistrials?
I have heard of that happening. I can't say that I personally know the names or the specific circumstances of those cases. But what I will say is that this isn't obviously a drunk driving case. This isn't a bank robbery. I can't think of a case that would better warrant the full resources of the district attorney's office being put behind it than pursuing justice for a murder victim and her family. So if ever there was a case to go to bat 3 times or more in the pursuit of justice, this would be the case.
As far as your contact with Anna Marie's family, dealing with them, what's it like for them to have this the second time they're going through this again?
It's heartbreaking. They have poured their hearts and souls into this. From the day they found out on April 2nd, 2010, that their daughter and sister had been strangled to death, this has consumed their lives. And it's taken an enormous emotional and physical toll on them, obviously, to go through 2 trials. But that's something we'll be discussing with them in the coming days.
Steve, I think after the first mistrial was declared, correct me if I'm mistaken on this, I think
We have no indications that they're unwilling or unable to proceed. It's just that we don't want to, obviously, within an hour of having this mistrial declared, put on blinders and charge full steam ahead without taking into account their feelings, their thoughts, obviously consulting with the district attorney, whose ultimate call it would be to proceed with the 3rd case. So I think just a step back at this point would be useful, but again, I would not urge anyone to read into one way or the other the fact that we're taking some time to reassess. Yes?
Steve, this may be outside the scope of your responsibilities, so I apologize in advance, but the word is that he had a life insurance policy that made Cara the beneficiary. Can you see this playing into whether or not she gets tried again?
I really don't know the specifics of any life insurance policy or what the status of that is. In terms of her being tried again, you mean her resources, or?
Well, if she were convicted of killing her, she would not be the beneficiary anymore, I would imagine.
I really don't know. I haven't been following that, and frankly, that's really beyond the scope of what we're concerned with. Did you have a question?
Yes. During this second trial, the defense claimed that the prosecution nor the police didn't look into enough alternate suspects. One of them being someone who Anna Marie had developed a relationship with before she went back home. I know you can't speak for the jury, but would you say that that was reasonable doubt?
I would say that the investigation thoroughly vetted all viable persons of interest in the case. Obviously, there were 2 names that surfaced more predominantly than others in the case. There's only so far that any investigation can go to disprove each and every potential boogeyman who's out there. But what I would say is that for any person for which there was a shard of viable, credible evidence indicating they may have been involved in this case, that lead was exhausted, that lead was investigated, and in our view, all of the evidence kept coming back to one person and one person alone, and that is Cara Rintala.
And when we talk about resources, how much of the district attorney's office resources are being used for this particular case?
In terms of extraordinary or unusual expenditures, there really aren't many. We haven't hired any high-priced private experts like the defense occasionally does in cases. Obviously, there's personnel expenditures, but frankly, the district attorneys in our office, they don't get overtime when they stay past 5, when they take work home with them, whether it be from the district court prosecutors to myself, working till 10, 11 o'clock at night, working on the weekends. None of us do it for the money, obviously, and we're not getting compensated for that. So there is an expenditure in terms of time and energy, but not necessarily a financial cost to the Commonwealth. Last question? You've already had 2.
Okay.
All right.
Is it a factor at all that the state is paying for the defense as well? Is there someone who has oversight over that who can decide if that could go around again?
To the best of my knowledge, an indigent defendant has the unlimited right to counsel, and that's nothing that would ever be abridged due to finances. So, unless there are any further questions,
Just one thing, and
Yeah.
you might have covered this already, but has there been, I know it's an early stage, but either through the process up to now or in gearing up for the second trial or now in the aftermath of the mistrial, has there been any talk of offering up a lesser charge, second-degree manslaughter, anything like that, that might give a jury some more latitude in making a decision?
even if there were such talks, I wouldn't be at liberty to discuss them publicly.